Is the GDPR illegal under EU law? Well, Meta says so, at least part of it, in a court challenge against the EDPB's opinion about its consent or pay process. I'll be looking at whether that is a waste of time. Also, TikTok is facing enforcement in the US on child privacy grounds, and the UK regulator has proposed, emphasis on proposed, a £6 million fine against a processor. So first up, this Meta case. This is not the first time Meta has tried something like this. It did not succeed in the last instance. This time they are taking the EDPB to the CJEU, and it's all about the opinion on Meta's consent or pay process. Meta makes 7 pleas in law. We don't have full arguments yet and probably won't get them, but here's a look at what they are alleging. So first up, interestingly, they are saying that Article 64.2 of the GDPR is illegal under Article 277 of the Treaty on the Functioning of the European Union, and also does not comply with the Moroni or Romano principles and violates the Charter of Fundamental Rights of the EU. So what does that all mean? Well, 64.2 is the process by which a DPA can request an EDPB opinion. Sounds pretty innocent, but Meta says that this has a kind of disproportionate impact on its right to do business. These opinions are not legally binding technically, but they are followed by data protection authorities when they enforce the law, and they're not directly amenable to court challenge. So this is Meta's problem. This document has very important implications and it can't be challenged in court, except insofar as Meta is attempting to do so here. This is all against Article 277 of one of the EU's most important treaties, according to Meta, and some other stuff around principles that are quite controversial. So either it's illegal or it should be applied very restrictively, according to Meta. Second up, the opinion allegedly violates Article 19.1 of the Treaty on European Union. So this is the other of the EU's major treaties. And that basically says that member states have to provide remedies for companies to challenge EU law. This, whilst not technically law, is, as Meta keeps saying, quite an important piece of act of an EU agency or institution and should be amenable to court challenge, but is not. It also, they says, ignores the Bundeskartellamt judgment from July last year, which found basically that Meta could offer some sort of pay or consent process, lots of caveats, and the EDPB does pay what I would say is lip service to that judgment in its opinion, but Meta says it basically tries to overrule the CJEU. Next up, the opinion is allegedly an illegal and disproportionate interference with Article 16 of the Charter. Now, the Charter is very snappy. This article basically says that the freedom to conduct a business in accordance with EU law and national laws and practices is recognised. Tech firms often cite this article to say this, well, usually the EDPB or a DPA is preventing us from doing business in the EU. That's against the Charter. So that's what Meta's saying here. It's interfering with its right to do business. Fourthly, Article 20 of the Charter states simply that everyone is equal before the law. Meta feels it's being treated unfairly by the EDPB, probably not totally unjustified, given that lots of companies have adopted consent or pay processes. Meta is just one of them. This is kind of how GDPR enforcement works to some extent. Someone made a complaint, no one complained about the other ones, or they have, but there we are. Meta thinks it's biased. The EDPB is biased against it. The fifth plea, that the opinion is a novel and incoherent obligation not found in the GDPR, basically saying that the EDPB is making the law up as it goes along, in violation of Article 52.1 of the Charter, which says that any limitation on people's rights should be proportionate and necessary and so on. And they also disagree with the EDPB's interpretation of consent and data minimization in the GDPR. Sixthly, And second to last, the EDPB again is accused of being biased, not an impartial body under the Charter. And lastly, the EDPB is allegedly ignoring Meta's right to be heard. So this opinion, Meta was not consulted before it was written. It has no means to directly challenge it. Therefore, according to Meta, it violates Meta's right to be heard. This gets to the nub of what might be the problem with Meta's case. If a DPA goes to enforce against Meta, they read this opinion and they then implement it in an enforcement notice, that would be amenable to court challenge. The opinion itself is not directed to Meta, therefore Meta might struggle to bring a case against it directly. Next up, TikTok is into more stormy waters in the US. This case is a bit more coherent than some of the other actions and laws taken against TikTok in recent years. It's brought against ByteDance and all its various sub companies, and it's by the Department of Justice on behalf of the FTC. So these are all allegations of COPPA violations, the Children's Online Privacy Protection Act, and they are pretty bread and butter stuff. So failing allegedly to provide notice on their website of how they use and collect children's personal information, failing to tell parents or make reasonable efforts to tell parents about what they're doing with their kids' data, failing to get consent, which is required under COPPA in most circumstances, from parents, that is, failing to provide a means for parents to refuse certain activities relating to their kids' data, failing to allow parents to direct TikTok to delete their children's personal information. This is all pretty basic COPPA type stuff, but it also allegedly violates a 2019 consent order brought by the FTC against what TikTok was then known as Musical.ly. So that also alleged various COPPA violations. So these activities kind of breach COPPA allegedly and also breach that 2019 order. Finally, the UK's Information Commissioner's Office, the ICO, has proposed an interesting UK GDPR enforcement notice against a processor. We don't see many of those, and we haven't yet seen one in the UK. This is, might be or might not be £6 million against a software provider known as Advanced Computer Software Group. And basically, they provide software services to the NHS, the National Health Service, and other organizations here in the UK. They suffered a ransomware attack, or one of their customers did, affecting 82,946 people. So quite a big deal. Some special category data there, or sensitive personal information, as the ICO insists on calling it. And the problem was that the customer account allegedly did not have multi-factor authentication. So interesting that the ICO has chosen to bring direct liability against the processor here rather than the controller. We don't have a full kind of provisional enforcement notice yet. And also, do take these provisional or preliminary enforcement decisions with a pinch of salt. The ICO has a bit of a history of overhyping its enforcement activity. So we had a proposed fine against British Airways for 183.4 million. That went down in the final event to 20 million. We had 99.3 million pounds proposed against Marriott that ended up as 18.4 million. We had TikTok again, was proposed a £27 million fine that last year turned out to be 12.7 million. We also have Snap, which received a provisional enforcement notice last October that was dropped altogether. So the ICO's bark, I think it's fair to say, is somewhat bigger than its bite. Well, that's all from me this week. Thanks so much to Privado AI, as always, for their support. I've been Robert Bateman. This has been the Privacy Corner, and I'll see you all next time.